It's recently been suggested in the media by experts that holding a party or other unlawful gathering while COVID-19 orders are in place could put you at risk of being convicted of manslaughter. Today on Don't Talk TV, I'm going to analyze the legal test for manslaughter, and give you my views on whether the Crown could secure a conviction. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Last week, Global News, among others, ran an article suggesting that people could be charged with manslaughter if they held a party in contravention of COVID-19 stay-at-home orders. Someone from the party got sick with COVID-19 and died. So here's one of the articles right here from Global News titled, quote, "Death due to COVID-19 parties could lead to manslaughter charges, experts warn," end of quote. And the article goes on to say, people who break health rules by holding parties that lead to death from COVID-19 should heed the warning from a British Columbia judge about facing a manslaughter charge, legal experts say. And it goes on to describe how Provincial Court Judge Ellen Gordon chastised Mohammed Movasagi this week as she sentenced him to 1 day in jail, a $5,000 fine, and 18 months probation. He had previously pleaded guilty to disobeying a court order, failing to comply with the health officer's court order, and unlawfully purchasing grain alcohol. Gordon called the event a crime, not a party, adding that it was something attended by people foolish enough to put their own and their grandmother's health at risk. The judge went on to say, if someone had been at your party, was infected and died, as far as I'm concerned, you're guilty of manslaughter, she said. If someone who had been at your party was infected and passed it on to grandma, as far as I'm concerned, you're guilty of manslaughter. Now, this is a rather exceptional comment to be made from the bench. First and foremost, the fact that this judge has already prejudged such a scenario where someone attends a party and later dies, that person would already be guilty. So certainly, in my view, this judge should recuse herself from any such case if such a case were to be brought before the court. But now I want to look at the test that's been laid out by the Supreme Court of Canada for proving a charge of manslaughter. And specifically, we'll look at manslaughter as a result of an unlawful act, for you'll see there's a few ways in which manslaughter can be committed. Then I will apply that test to a potential case such as the one described by the judge and see whether the charge could stick. So here we have Section 222 of the Criminal Code of Canada, homicide. It describes that there's both culpable and non-culpable homicide. And subsection 5 is the one of interest here, since it lays out the ways in which a manslaughter could be laid out. So a person commits culpable homicide when he causes the death of a human being, A, by means of an unlawful act, B, by criminal negligence, C, by causing that human being by threats or fear of violence or by deception to do anything that causes his death, or D, by willfully frightening that human being in the case of a child or sick person. So it would seem that subsection A would be the most likely charge that the Crown would use if they were to charge someone. The unlawful act being the breach of an act of one of these provincial acts, such as the Reopening Ontario Act, and hosting a party or large gathering in contravention of that act. So one of the leading cases on manslaughter as a result of committing an unlawful act is Her Majesty the Queen in Gossett, or Gossett. It's a 1993 Supreme Court of Canada decision. And just briefly, it was the facts of this particular case was a police officer who shot and killed a suspect was charged with unlawful act manslaughter. So the unlawful act was careless use of a firearm, contrary to 86 sub 2 of the Criminal Code. The officer had drawn his pistol, ordered an individual who was fleeing to stop. He testified that his intention in drawing his pistol was to intimidate the person, for them to stop. The person did stop, and then the officer accidentally discharged a firearm, shooting this individual in the head, killing them. So starting at page 98 of the decision, Chief Justice Lemaire lays out the elements that must be proven to convict an individual. So here, starting at just under line H on page 98, Justice Lemaire says, quote, "In Her Majesty the Queen in Crichton, Supra, I set out the following elements which must be proven in order to convict an accused of unlawful act manslaughter under section 222 sub 5 sub a. 1. That the unlawful act caused the death of the victim. 2. That the accused has satisfied the fault requirement of that unlawful act, which cannot be one of absolute liability. So what that means is, to satisfy the fault requirement, the individual has to have intended the action that they did. Absolute liability is where intention doesn't matter. You're guilty. All the Crown needs to do is prove that you actually committed the act, whether you intended to commit it or not. 3. That the unlawful act is objectively dangerous. And 4. That the unlawful act was one from which a reasonable person, in the circumstances of the accused, would have foreseen the risk of death. So let's assume a situation similar to the one in the case of Mr. Movasagi. Let's assume there's a stay-at-home order in place, as there currently is in Ontario, that gatherings of any number of individuals are forbidden, that there's a substantial penalty, in Ontario's case, $10,000 penalty for an organizer of such a gathering, and that in those circumstances, someone has a large gathering, a party, like Mr. Movasagi. He had a condo where he had a large number of individuals and partying and drinking. So let's assume there's a situation like that, and 2, 3, 4 weeks after that, one of the individuals who attended the party goes to the hospital, and they're diagnosed with COVID-19 and they end up dying. In that factual scenario, let's look at what would be required for the Crown to secure a conviction. So we look at number 1, that the unlawful act caused the death of the individual. So here the unlawful act would be the hosting of the party. So the Crown would have to prove that the party caused the death of the individual. So to do that, they would have to prove a number of things. 1, they would have to prove that the individual died because of COVID-19, that COVID-19 is specifically what killed the individual. It would not be sufficient to have a situation where the individual was merely diagnosed with COVID-19, had a positive COVID-19 test, but died by suicide or died in a car accident or died of something unrelated to COVID-19. They would have to show that it was actually the COVID-19 that killed the individual. Right off the hop, this may be extremely difficult to prove beyond a reasonable doubt, but even assuming the Crown could prove beyond a reasonable doubt that it was COVID-19 and nothing else that killed the individual, they would have to prove that that person contracted COVID-19 at that specific party. Now, in order to do that, that person would have had to have been tested very shortly before the party and received a negative result, have had no intervening contact with individuals, attended the party, and then had another test for COVID-19 after the party, again with no intervening contact with individuals, to prove that it was specifically at that party that they contracted COVID-19. Now, this too would be extremely difficult because of the incubation periods involved with COVID-19 and the risk of false negatives or false positives. So to put that into context, I'm looking at a fact sheet titled Understanding COVID-19 Testing, which I got off of the Health Canada website. So this fact sheet warns that false negative test results can result in people being unaware of their infection and could infect others. The fact sheet talks about testing accuracy and says it depends on when you get tested. Test accuracy is based on a 5-day incubation period from exposure to symptoms. So if they're tested within 0 to 2 days of initial exposure, there's very low virus count, and about 98% of the time, the virus will not be detected, and they'd have a false negative. Within 0 to 5 days, you've still got 50% not detected. And so they indicate that the worst times to test are within 0 to 5 days of being exposed or actually having the virus into your body. As it says here, up to half of those tested will get a false negative result and may infect others during those first 5 days. And it's only after 5 days that you start getting higher positivity, you start getting lower false negative rate. So this situation with false negatives makes it nearly impossible to prove beyond a reasonable doubt that an individual did not have COVID-19 before they attended that party. They may have tested negative, but we don't know what if the test before the party they had been exposed to COVID-19 within 5 days and it was a false negative. So because of that incubation period and the risk of false negatives, in my view, it would be nearly impossible for the Crown to prove beyond a reasonable doubt that the unlawful act caused someone's death in the hypothetical I've laid out. Now, looking at Part 2, the fault requirement, as I indicated, it cannot be an absolute liability situation where an individual simply needs to be proven that they had the party. There has to be some ill intent proved. And when I look at case law such as sexual assault caused bodily harm or aggravated sexual assault cases involving individuals who've been diagnosed with HIV and then have sexual intercourse with other individuals without warning them, and those individuals contract HIV. In those cases, the Supreme Court has held that individuals need to have at least some knowledge that they may have HIV. One case I'll just look at quickly in that regard is Her Majesty the Queen and Harold Williams. It's a 2003 Supreme Court case. And the important section here is paragraph 28, where the Supreme Court said, once an individual becomes aware of a risk that he or she has contracted HIV, and hence that his or her partner's consent has become an issue, but nevertheless persists in unprotected sex that creates a risk of further HIV transmission, without disclosure to his or her partner, recklessness is established. In the present case, however, the agreed statement of facts does not permit us to draw any firm conclusions about the state of the respondent's awareness of the danger or even the risk of the danger of HIV infection prior to November 15th, beyond the bare fact that he was asked to take a test. And in that case, the accused person, the reason November 15th was mentioned is that was the date that that individual was tested and learned that they were potentially positive for HIV. So in my view, the person running the party would have to have at least some reason to believe that he or someone else attending the party may have COVID-19. And I think that would be very difficult to prove as well. The way it might be proved is if he or she was aware that certain individuals attending the party had been asked by their work to testify, or had been asked by their work to be tested, or they'd recently been out of the country, the things on the typical COVID questionnaire. But absent any of those things, absent evidence of any of that being in the mind of the party organizer, I think it would be very difficult for the Crown to prove this second element of the case. Now, in terms of the third element, that the unlawful act is objectively dangerous, just for the purpose of this hypothetical, let's assume that having a party in the COVID-19 environment is in and of itself objectively dangerous. There's certainly arguments that could be made either way, but let's assume that the Crown would have physicians come and testify as expert witnesses and swear up and down that it's objectively dangerous to have any sort of gathering. That may be one that would be easier for the Crown to prove, and the defense would have to call conflicting expert evidence to contradict that. But then we turn to the fourth part of the test, that it would have to be reasonably foreseeable that death could occur. Now, this, in my view, is another element that would be extremely difficult for the Crown to prove in light of the death rate from COVID-19. So I've got up on my screen here, I did a Google search for death rate COVID Canada, and Google, they're part of the establishment, so they're presumed to be reliable, and they're providing their data is mined from official sources, as is Wikipedia. And Google's getting its numbers from Wikipedia here, and Wikipedia is getting its numbers from Health Canada, CDC, the various provincial agencies. So I would suggest that certainly for the purposes of court, these would be accurate numbers to go by. So if we look at here, the statistics, number of cases versus deaths. So we look at 1.22 million, since March of last year, 1.22 million people have been diagnosed with COVID-19. And so let's assume that 100% of the people who've been infected with COVID-19 have gone for a test and received a positive result. I think that's highly unlikely, but for the sake of argument, let's assume that every single person in the country who's ever been infected with COVID-19 had a test and received a positive result, and therefore is reflected in this 1.22 million. Out of that 1.22 million, there have been 24,203 deaths. Just by basic math, you divide 24,203 by 1.22 million, you get a death rate of 2%. So that brings up the question, does 2% chance of death translate into reasonable foreseeability of death? I would suggest that it does not. And as an example, I don't know what the percentage chance of killing someone is if you get behind the wheel while driving drunk, but drunk drivers who kill individuals are not charged with manslaughter. They are charged with impaired driving causing death. I suspect that that's because the reasonable foreseeability of death occurring is not high enough, but I think anyone would agree that it's much more dangerous to get drunk, drive your vehicle, than it is to have contact with another individual when you may or may not have COVID-19. So having gone through that test, I respectfully disagree with the experts that CTV consulted that suggest that a manslaughter charge and a manslaughter conviction would be likely in the case of an individual holding a party in contravention of COVID-19 stay-at-home orders. Now, I absolutely am not advocating or suggesting that people should hold such parties. This video is simply an analysis of whether a manslaughter charge would be appropriate or could be made out, and in my view, manslaughter is absolutely not appropriate. This video is not legal advice. If you have a situation where you need legal advice, contact a lawyer. You can call another lawyer or you can call myself. My 1-855 number and my website are listed below. If there's any topics that you'd like to see me cover, please leave a comment in the comments box below. If you found this video helpful or informative, please consider liking, sharing, and subscribing.